Hello, I am Esther Omodayo, a legal intern with Alem Solicitors. In this video, I will be giving a lecture on the justiciability and cognizability of interception of private communications under the law. I will start by defining justiciability and cognizability. Justiciability refers to the limits upon legal issues over which a court can exercise its judicial authority, while cognizability refers to the capability of being judicially determined and heard. As a matter of general rule, Section 37 of the Constitution of the Federal Republic of Nigeria, 1999, as amended 2011, states that the privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communication shall hereby be guaranteed and protected. In furtherance of this, Section 12, subsection 1 of the Cybercrime Prohibition Prevention Act 2011 criminalizes the act of unlawfully intercepting or interfering with private communication through technical means and states that such a person shall be liable to fine of not more than 5 million naira or to imprisonment of not more than 2 years, or both fine and imprisonment. In Nigeria, however, or under the law, however, we know that when there's a general rule, there are exceptions. Section 45 of the Constitution of the Federal Republic of Nigeria, 1999, as amended 2011, states that nothing in sections 37, 38, 39, 40, and 41 of this Constitution shall invalidate any law that is reasonably justifiable under a democratic society. And paragraph A goes further to state that in the interest of defense, public safety, public order, public morality, or public health. In Nigeria of today, there are two laws that have been promulgated with regards to circumstances under which interception of private communications can be lawful. These are the Terrorism Prevention Act 2011 as amended 2013 and the Cybercrime Prohibition Prevention (ETC) Act of 2015. Under Section 29 of the Terrorism Prevention Act 2011 as amended 2013, it states that without prejudice to any other law, the relevant law enforcement agency shall, with the approval of the Attorney General of the Federation, who may, with the approval of the Coordinator on National Security, for the purpose of prevention of terrorist acts, or for the purpose of detection of offences related to terrorist acts, or for the prosecution of offenders under this act, apply ex parte to a court of law for an interception of communications ordered by the judge. Subsection 2 goes further to state that upon application for such order, the judge may order a communication service provider to intercept and to retain communications received or transmitted or about to be received or transmitted by that communication service provider, or the judge may order the relevant law enforcement agency to enter into the premises and install devices for the purpose of intercepting and retaining communications data, and also to remove such devices and retain them for the purpose of intelligence gathering. The judge can also order the law enforcement agency to go on covert operations for the purpose of retaining communications or to intercept communications with regards to suspected terrorist groups or terrorists themselves for the purpose of intelligence gathering. Also, under Section 39 of the Cybercrime Prohibition Prevention (ETC) Act of 2015, it states that upon the reasonable suspicion that data of any electronic communication will be required in criminal investigation or criminal proceeding, the judge can order the communication service provider to intercept or permit the service provider to disclose information with regards to communications data, and also order the service provider to assist competent authorities in the process of gathering information or communications data. Also, the judge can order the law enforcement agents through technical means to intercept, to retain, or to retrieve communications data. It is also sacrosanct to state that under Section 40 of the Cybercrime Prohibition, Prevention, etc. Act of 2015. It is an obligation upon service providers to disclose information upon the receipt of the order by the judge, to disclose information of people, of their subscribers, and also to assist the competent authorities in the purpose for the purpose of conducting criminal investigation. As as I believe we know, the principal regulatory agency for telecommunications in Nigeria is the Nigerian Communications Commission, and the Nigerian Communications Commission has made attempts to have its own regulation with regards to lawful interception of private communications. The bill was introduced to the National Assembly in 2015, and we believe that this bill is currently being worked upon. We earnestly expect and look forward to having a regulation by the sole regulatory agency itself on lawful interception of private communications. So as I have stated earlier, the circumstances that are provided for under which private communications can be lawfully intercepted have been discussed in this lecture. I hope you have been able to learn one or two things. To know more about interception of private communications, you can visit our website at www.alemsolicitors.com or our LinkedIn page at Alem Solicitors. Thank you so much for listening.